Guys, it's Ron and Debbie. We're back for another edition of Ask Ron. Ron, our first question this week comes from Alex Arriaga from Houston.
Hey, Alex.
In Texas, we buy pretty houses with owner financing. If we intend on finding a lease option tenant or buyer with owner financing before closing, what do you say to the seller to get them to allow you to show the house before you close, either occupied by the seller or vacant? And is there any language in an agreement that states you can show the house before closing?
All right, well, first of all, if you want access to the house to show it before closing, you should put that in the agreement in paragraph 18 where it says additional provisions. You most certainly should have that understanding with the seller. And if it's vacant, I just tell them that I'd like to show it to potential occupants while we're waiting to close. If it's an issue, I just don't. I'll wait till after we close. If it is occupied and you're going to close before they get out, then I will simply ask them if they would like to show it for me. They don't have to talk money. In fact, I don't want them to talk money. I tell them so. Just let me know when they've come and gone and answer any questions they have on the house. I usually throw $500 at them if I find the tenant buyer I like before they get out of the house. Of course, they all like that. If, however, the house is not ready to show and I think we'd be doing more harm than good to send a buyer over there, then I won't do it until they're out of the house. So that's a case-by-case decision.
All right, our next question is from Jason Ham, and Jason is right here from our own backyard, St. John's, Florida.
Hey, Jason.
All right, he says...
That's down there where Iggy's Seafood Shack is, Jason.
I bet he's been there.
It's required, Jason. It's St. John's, Florida law.
Okay, he says on a free and clear house, if the owner wants money now, they can refinance the property to get cash now, and I can put a tenant buyer in the house to pay their loan.
Right.
If the owner asks who will pay for the refinance expenses...
They will.
What do you tell them?
They will. It comes out of your loan proceeds.
Okay. He said, I'm unsure if I tell the owner they are responsible or should I, or the tenant buyer pays those expenses.
Jason, tenant buyer has nothing to do with your seller's refinance. Absolutely nothing. That conversation will never come up with your tenant buyer. No, never, ever. The person getting the loan, all the closing costs comes out of the loan. That it probably will never come up either. Anybody going to refinance knows that the costs are going to come out of the loan. So you're asking the question likely you will never be asked.
All right. Next, Michael Williams from Oregon.
Michael?
Hey, Ron, I heard somewhere that you can actually buy more house than the bank says you can afford. Can you explain to me in detail how this works?
Well, now, I'm not sure what the meaning of your question is. Almost anybody can buy more house than the bank says they can afford, but I'm not sure what you're talking about. So maybe if you could identify that and clarify it so that I can get the gist of it, I'll be able to answer it.
Okay. All right. Next, from Evangeline Benedito from New Jersey.
Hi.
I'm getting FSBO leads from my email and want to call them, but when I check the public record, I saw a new owner's name. I was thinking he probably sold it on terms and the buyer failed or missed the payment. That's why he put it back on the market. Can I still call the sellers and find out what's going on?
You're killing me, girl. First of all, why on earth are you even calling public or checking public record on anybody for anything? You are really just looking for something to do to stay busy, girl, because you're not accomplishing anything in the course of buying and selling houses. Here's how it works. Generate lead. VA calls lead. You call the ones that say yes. Who cares what the public record says until you get a seller that says yes to terms and you collect all the information on them, and only then if you decide you want to move forward based on the facts they give you. Quit working so hard at killing time. Work more at getting appointments and dealing with the people who want to deal with you, and get out of this minutia phase and let's get some deals going.
Okay, next is Michael Bradford from Oklahoma.
Michael?
I have a seller whose common law wife passed away. She named him in the will to receive the house. According to the county assessor's office, the deed is currently in her name, but shows CO and his name. He cannot locate the original deed. He tells me he will sell me the home well below ARV if I can help him get the title clear and in his name.
All right. Well, first of all, you don't ever have to locate an original deed. It's not like a car title. Nobody has to produce a paper product called a deed. They are all recorded down at the courthouse, so any title company checking the title will see the original deed on public record. As far as clearing up the title, that is a question that you need to ask a title company or your attorney on exactly what it is that needs to be done to clear up the title, and then take it from there. So let the people who deal with the title, and let them advise you on what best to do, because I don't really have any idea what your title issues are without looking at a title report.
Okay, next is from Joe Lagenza from Pennsylvania.
Joe?
If I have a property under contract with a motivated seller, I have a purchase and sale agreement, am I allowed to sign a purchase and sale agreement with a buyer, then assign my contract back to the seller?
Yes, you are. That's probably done 10,000 times a day all over the United States. That's how it works. When you're wholesaling a house, you're just simply assigning your contract with the seller to the buyer. Sometimes when we're in the pretty house business, we assign our contracts with the buyer back to the seller. Either way, there's nobody stopping you from doing it, but the buyer or the seller. Do it anytime you like.
Okay, this is from James Butler from Ohio.
James?
Hey, Ron, Alton gave me some good pointers on this on the Q&A call, but I'd like to hear a little more from you.
Okay.
I recently bought a house from a young couple about to file bankruptcy. They owed $77,000. I bought it on a wraparound land contract for $77,000 plus $2,000 cash. I've since sold the property on lease option for $129,000. 10% down cash, 10% down, and cash flow $400.
Good.
I've brought the loan current, and have been making payments to the lender.
Right.
In case you haven't guessed the rest of the story, I just received a letter to creditors. The meeting's in a few weeks. My attorney has advised that even if the trustee would want to work with me, the lender will probably call the lender.
Your attorney has no idea what the lender will do, so that's baloney. If the lender does want to call the loan due, they can, but frankly, I doubt they will, especially when they see somebody in the house making the payments. And if that were to happen, your next move is to see if you can get the new buyer qualified now. Now, if that doesn't happen, we can have a discussion about some other things that you might be able to do, but you do have legal rights. You own that house. You bought that house. And you're in a pretty good position, actually, because you're not personally liable for anything, and you can create havoc on the whole process and give yourself plenty of time to get that buyer cashed out. However, I think we're probably worrying about something there's no need to worry about. The bank is not going to call the loan due if it's current. I'll bet you the biggest lobster in, where does he live?
Let's see, Ohio.
Ohio. Oh, there aren't any lobsters in Ohio. I take that back. Anyway, don't worry about it until your attorney tells you got something to worry about. And right now, I don't see it. I don't think the bank's going to call the loan due. He doesn't have enough experience in real estate deals to probably understand that. He's just guessing.
Okay. Hopefully that's what Alton told him as well.
Yeah.
Okay. This is from Jeffrey Denny from Ohio.
Jeffrey?
Need some quick help if possible. I have a deal that
My specialty is quick help.
I have a deal that I must structure a purchase and sale contract for by morning. I don't know when he said
I don't know which morning.
Yeah, I know. I have done many subject to deals before. I always put them in a trust to avoid any deed transfer due on sale issues.
Well, okay.
I am new to the wraparound mortgage technique. Just started the terms course yesterday, but I want to go under contract to a wrap with a FSBA owner tomorrow. The contract for the terms course does not seem to fit the transaction if a trust is required. I will
Stop.
Okay.
The land trust has nothing to do with the wraparound mortgage. That's two totally different deals. The land trust is how you're going to take title. The wraparound mortgage will be created by your attorney. It'll be from your land trust to the sellers. I will tell you, however, your attorney will probably advise that you use a land contract in Ohio and not a wraparound mortgage because they're more widely acceptable. Either way, well, this is a big difference, because if you buy it on a land contract, there is no land trust because you're not taking the title directly into the trust. So you might want to just use an LLC as the buyer if they're going to ask you to do a land contract. But if you take title, literally title passes, as it does not do in a contract or a land contract, then you might just use an LLC as the buyer. Okay?
All right, sounds good.
That
Okay,
answer the rest of the question?
we've got. Well, I think you answered it all with that. Okay, so next from Aaron Powell from Georgia.
Aaron?
Hey Ron, I've got a subject to deal under contract. Underlying loan is $156,000, and I think it would appraise for just under $200,000.
Nice.
Monthly payment on underlying loan is $13.40 a month, of which $162 per month is due for mortgage insurance premium. It is feasible to try to get rid of the mortgage insurance premium payment after
Now-
closing.
You can't do that if it's not your loan.
Okay.
Only the borrower can petition to get rid of mortgage insurance after it's paid down 80% of its value.
Okay, that's what he was asking. And then, so how should he proceed?
Nothing.
Okay.
He should proceed by selling the house on the lease option and doing normal business and forget about the mortgage insurance because he's not in control of it.
Okay. And lastly, he asks also in one of your courses, it's mentioned that you can get the seller at closing to put the property into a land trust and then simply assign you the beneficial interest as a way of transferring title under the radar. Do you still recommend this method?
If you heard me say that, it was a long time ago because I haven't been telling folks to do that for at least 10 years. At least 10 years because honestly, when you do that, all you're doing is avoiding transfer tax, and that is not something that your county is going to like, and it very well may come back to haunt you a year later and you'll have to pay that plus a penalty. That would be the only reason for having a seller put a property into a trust and then assigning you the trust, and that's to avoid the transfer tax, because any due on sale clause says that if a major interest in that property transfers, not just the title, and when they assign you that trust, they are transferring a major interest, and that will trigger the due on sale clause. But I think you're worrying too much about that to begin with. I haven't done that in a long, long time because I don't care what the bank thinks or says. They're not going to call the loan due. They're just going to collect the payments and forget about it. So you're taking needless steps, trying to carry on conversations with the seller, trying to explain to them why you're doing all of this, and it's all just a waste of time. Just take title in a land trust and forget about it.
All right, Ron, that's all we have.
All right, see you guys next week. Hey, I'll be up in New Jersey doing the Quick Start boot camp next week. You still got time to get in if you want to call our office and register. So we got one scheduled every month except May, because May I've obligated to put my wife in a big old RV and go north and travel up to somewhere where we're going. Don't know for sure yet. I know it's up north, and that'll take place the entire month of May. So maybe sometime if you guys get to work, you can get in an RV and go away for a month as well. See you next week.